basically, I salute you all. Thanks for watching and thanks for being on. We are under law of torts, and the topic of emphasis or the topic of concern that we are looking at, it is the topic we are looking still under trespass to goods, but we are looking at the defenses and remedies. The defenses and remedies that are available for the defendant under trespass to what? To goods. First of all, we shall start with the defenses. And what you have to know, one of the defenses, let it be death, let it be conversion, let it be trespass to a chattel. One of it, there's a defense of just 30. Yeah, just 30. But the title, or where a third party claims to have a better title to the goods. And the just 30 basically applies as a general rule. A defendant cannot plead that the plaintiff is not entitled to possession against him, because the third party is the true owner of the what? Of the chattel. That's the general rule under just 30. Basically, the defendant can plead this defense, or he can plead this defense claiming that that is the true owner, or the third party is acting with the authority of the true owner. You get, when we read the case, there is the case of COP versus Ogwang Tayo. That is a good case, basically whereby the law, or they stated very well, or in that case they stated that a person cannot claim just that of a third party unless the person is defending on behalf of or on the authority of the true owner. You understand? Basically, here what you have to know, this doesn't, it's kind of an agent, you are an agent of a principal. Oh, you have what? You have ownership of what? Of the commodity. So that's why this defense comes in. That's why that defense comes in. And there is also subsisting bailment. Why do we mean subsisting bailment? Basically, remember bailment, the bailee transfers possession but doesn't transfer title. So if there is still the subsisting bailment, which means you the bailee. Yeah, is it? You the bailee. You have the legal what? You still have the legal possession. You understand? So however much you still have the ownership of the bailment. So somebody cannot sue you under trespass to his commodity because the bailment is still what? Subsisting. You understand? Realize that sometimes we may say that I've given you this property, but I'm coming it from after a week. But you come before the week, I refuse, which means I'm still acting under bailment. There's also a subsisting lien. We all know that what is a lien. A lien is that whereby the defendant retains what? Property until his payment is what? Is cleared. You understand? It's like confiscation. A lien or subsisting lien is like, let me give an example whereby you take your shoes to the cobra, and the cobra refuses to give you back your shoes until you make payment of the what? Of his work. So that is a subsisting what? Lien. Then we have also temporary retention. What do we mean by temporary retention? Temporary retention basically means that the defendant may refuse to give up goods until he's taking steps to verify the title of the plaintiff who is claiming to be the owner, or before he handles goods over the what? The plaintiff. Then there is also limitation of time or lapse of time. When you read the Limitation Act, all tort cases take what? Take 2 years. Understand? So there is also that time lapse. Once 2 years elapse, you can't bring an action in court, or you can't bring an action in court. So put that in mind, or bear that in mind. Also, whereby a defense this can also be a defense whereby the plaintiff has no sufficient what? Has no sufficient title to the property. There is also a defense that is good. There is also what they call innocent delivery, We have seen under conversion there is what they call wrongful delivery, but here we are looking at innocent delivery as what? As a defense. Basically, there is also court order, enforcement of a court order or the legal process such as levying of execution of property under which a writ of police taking away goods, among others. When police enters, takes away the goods for maybe investigation, that is done under legal what? Process. So there is court order or legal process as a what? As a defense. Then there is also a inevitable accident. Sometimes you realize that you can damage someone's property by accident. So that's why we put inevitable accident, which means you couldn't escape that accident. So it can also be a defense. You understand? So those are some of the defenses of what? Of trespass to goods. Let it be detention, let it be under conversion, let it be under trespass to chattel. Then there is also the remedies that you are looking at under trespass to goods. Remedies. And what you have to bear in mind under remedies, we also have the claim of return of the chattel. You understand? There is claim of return of the chattel, there is replacement of the chattel, there is claim for the market value of the chattel in case it was damaged. You can claim the market what? The market value. There is also damages, can be specific, general or nominal. You understand? As we have said that trespass to chattel is action per se. Even if there is no proof of damages, the court can award you what? Nominal damages. Then when you look also, or when you move further, or when you move further about still the remedies that you can plead, there is also an order for delivery. You understand? Order for delivery or specific what? Restitution of the goods. You understand? So basically, note that in mind. There is also an alternative order for payment of the current market value. You have seen that you can claim for the market value of the what? Of your commodity. You have seen general damages, specific. We all know them. You get, and basically that's the essence, or that's what I can give about the damages or the remedies under trespass to goods and the defenses. So I just thank you for listening, and thanks for being on. Stay blessed. I just urge you that you look for more cases as you can for you to pass this course unit or for you to excel in this course unit. Love of torts is a civil wrong way, basically, whereby the case law defines it more better than any other law. You get, the case law is the best law under the law of torts. So bear in mind or put that in mind. Thank you for listening.